Hello, my name is Diana Damian Martin. I'm a Roma-Romanian woman in my 30s with short black hair, and I'm wearing an orange and white top, and I have a blurred background behind me. I'm a researcher and cultural organizer with Migrants and Culture, and I'm happy to welcome you to our Employment and Immigration webinar. This is a resource to support freelance cultural worker on their employment and immigration rights. This event is accessible on the Freelance Futures research page and online. And this event is part of Freelance Futures, a summer program of learning and action for equitable conditions in culture. So I'm joined today by Eva Doerr and Finnian Clarke. Eva specializes in all areas of public and human rights law, with a focus on immigration and asylum law and challenges based on the Equality Act. She regularly appears before immigration tribunals and the administrative court and has particular expertise in retained EU law post-Brexit and refugee family reunion in Europe. And as a specialist in all areas of immigration law, including family, asylum, deportation, detention, nationality, and trafficking, she has experience and a regular particular interest in complex judicial review challenges. And we're also joined by Finnian Clarke. Finnian is a legal caseworker at United Voices of the World, a trade union working predominantly with migrant and precarious workers. And he's a future pupil barrister at Doughty Street Chambers starting in October 2022. So in this session, we're going to focus on working cultures for freelance and migrant freelance culture workers. And we're also going to talk a little bit about taking agency in a hostile environment. So I'm going to ask the questions and I'm going to invite Finnian and Eva to respond. And you're welcome to also join or extend the conversation on Mighty Networks as well if you're taking part in the Freelance Futures program. So I'm going to start with a question around knowledge. What are some of the key areas of knowledge freelance culture workers and migrant culture workers need to be aware of? And kind of tagging onto that, are there any major changes in employment and immigration law that affect migrant culture workers? Finnian or Eva want to start?
I'll go ahead first. So I'm a white British male in my 20s with brown hair, wearing a blue shirt and glasses. I'm here with a United Voices of the World flag behind me. One area I think that that would be really helpful for people to know about, a key bit of knowledge, is about worker status, or about their employment status more generally. In employment law, we have really three categories of people. There are those that are employed, there are those that are self-employed, and there's also this intermediate category of workers. And the boundaries between those three are not always clear, but they all have different definitions and they all have different rights attached to them. So individuals with employment status get all employment protections, such as unfair dismissal protection if they work for 2 years, as well as discrimination law and all many other things as well. Worker status is the middle ground where workers get national minimum wage protection, they get whistleblowing protection. Some of the big ones that workers in this sector may be thinking about are holiday pay and also rest breaks under the working time regulations. I'll come on to how we define those categories and their boundaries between them. But the big change, I guess, in this area recently is probably the Uber case in the Supreme Court last year, where the Supreme Court was dealing with worker status and found that workers, really the worker status definition is quite a straightforward question, whether you're a worker, which is, do you perform a contract personally for, do you perform work personally for an employer? And you don't look, first of all, or even at all, at the contract, the written contract between you. You just look at the reality, the practical reality between the worker and the employer, to see whether really what's going on here is whether you're genuinely self-employed, you're a third-party person, you're a client, or you're a worker who's controlled and you're performing work in that capacity. So that's the big change. We'll talk a bit more about that shortly, but that's something that it would be good for workers to have a good understanding of.
Okay, I think I'll take over from Finnian there. Now, I'm a woman in my 30s with blonde hair. I'm wearing a black t-shirt and I have a blurred background. Now, firstly, to talk a bit about key areas of knowledge. Now, in relation to immigration law, in my view, there are a number of things that are really important to know. One, it's really crucial to establish whether you have the right to work or whether you don't have the right to work. And there are some immigration routes available that you may not be aware of. So it's just really good, or you may even have the right to work, but you're not aware of it. So really understanding whether you have the right to work is really important. Now, if you know that you have immigration status, then you also need to know whether there are any restrictions or conditions placed on your right to work. So whether it's somehow restricted or whether you can work in whatever fields you'd like. Now, if you don't have immigration status, then it's really important to kind of figure out what options may be available to you, because work and employment can be a vehicle for you to regularize your immigration status. And that actually brings me to the second part of the question, which is the recent changes in immigration law. And Brexit has brought about a major shift really in immigration law, with European nationals no longer having preferential treatment. That really led to an opening up of other routes within immigration law. So what used to be called the Tier 2 skilled worker scheme has now become the skilled worker route. And it's much more open and much wider, and much more people qualify under it. Because, for example, salary levels are significantly lower under the skilled worker route as opposed to the Tier 2 worker route in the past. So it's really important for you to understand what this is and how you may be able to benefit from these routes.
Thank you both. What are some of the key areas of discrimination that you see in your work by employers for freelance culture workers and migrant culture workers specifically as well?
We see a number of forms of discrimination on a number of different angles, really, in the work we do. One of the big areas, particularly in relation to migrant culture workers, is nationality discrimination, or where nationality discrimination is disguised as something else. So you might, for example, have employers imposing requirements that you speak a certain language, or even that you have a certain accent. We come across sometimes. What that really is a proxy for is discrimination against migrants. And while the employer will pretend, well, they'll say that this is something that applies across the board, they're not discriminating against everyone. What we tend to argue is that it's indirect discrimination, namely that they have what appears to be a neutral practice. Everyone must speak the same language or something similar. But that requirement has a greater impact on migrant individuals. They're less likely to be able to comply with that requirement. So that's a form of discrimination that's protected under the Equality Act. We also have discrimination cases where employers target individuals on the basis that they assume that they may not have they may not have a right to work, or they may have some insecure immigration status. So we have cases where workers are required to undertake certain tests, and they're often punished because of their insecure worker, because of their insecure. Sorry, I've really rambled there. I might edit that bit. The fact that a worker has insecure immigration status is sometimes used against them in the workplace, where employers know that they won't have claims brought against them because individuals are concerned about their insecure worker status. So what you can do about that, we maybe will come on to, but though that's another area where we see workers be discriminated against on the basis of their status.
Eva, is there anything you want to add to that?
I think Finnian has really explained everything that can be said in response to that question.
Thank you. The next question is for you, Finnian, which is, what are some of my key rights as a freelance culture worker?
Well, the answer to that question in the employment law context does depend quite heavily on your worker status, like I talked about earlier, whether you're classified in law as an employee, as a worker, or as someone who's freelance or self-employed. As I said earlier, whether you fall into one of those categories is not necessarily obvious. Lots of people are misclassified by the people they work with. For example, certain contracts will say that you're freelance, you're self-employed, when the reality is there's a degree of control over your work by an employer. That means that as far as the law is concerned, you actually do have worker status or even full employee status with all the protection that brings. So it really does depend. And I'd encourage people to seek advice about their worker status if they're not sure and they feel like they are actually subject to the supervision and control of an employer. So what are those rights? Well, starting from people that are genuinely freelance workers and building upwards, people that are correctly classified as freelance or self-employed, their rights are primarily determined by the contracts they have with clients. So what you get under that contract is pretty much the extent of your protection. So if they say you'll be paid £100 a day or whatever it happens to be, then you have a right under that contract to that, but you don't have access, for example, to minimum wage protection or holiday pay protection. There are some individuals with in certain contexts in culture and other sectors where you're classified as something called self-employed plus, which is a bit of new speak for individuals that have some further protections than ordinary self-employed contracts. But really, again, that's the same as what I've been talking about before, which is that their protections are determined by the contract themselves rather than by law. Freelance cultural workers that are actually really workers, limby workers, as they're sometimes called, rather than being self-employed, they have a significantly more protection under employment and equality law, not least the Equality Act and the protection from discrimination. Also, as I mentioned earlier, national minimum wage, whistleblowing protection, the right to rest breaks, and crucially, I think in this sector, annual leave that's paid. So those are some of the really beneficial rights that individuals that can prove they have worker status, either because the employer agrees to it or because the tribunals and courts have said so, they get access to a lot more protection.
Thanks, Finnian. And Eva, one just for you. What are some of my worker routes as a migrant culture worker outside of kind of sponsorship through employment?
Yes, so I spoke earlier about the possibility of using work as a vehicle to gain immigration status. So this is really what I'm going to talk about. In my view, the most useful route is the route I already mentioned, and that's the skilled worker route. Now, you would need to be employed by the organization that you're working for, and that organization would need a sponsor license, and then give you an endorsement, and through that, you'd be able to be or become eligible for the immigration status. But as I said earlier, the requirements have really gotten much easier to meet. And that's, for example, skill levels and salary levels have dropped. And that is why it's available for many, many more people as it was earlier. So it is well worth looking into. I know that a lot of organizations haven't or have never really considered getting a sponsor license, just because it was so very difficult to actually sponsor anyone under the old style pre-Brexit tier 2 route. But I would just encourage everyone to have a conversation with your workplace or any prospective workplace. And if they don't have a sponsor license, to maybe encourage them to get one, because it is then possible to get immigration status through that. Now, there are also a couple of other routes that I should mention, but they're much harder, or that is my understanding at least, they're much harder to access. And that is one, the global talent route, where there's a specific subsection for arts and culture workers, but it requires you to get an endorsement. And my understanding is it's quite difficult to access it. And then there's also a tier 1 entrepreneur route, which is probably even more difficult to access. But for completeness, I think these are different routes where work can become a vehicle for immigration status. Outside of that, it's important that you look into your personal circumstances, because there are various other routes. For example, if you have any connection to European law or various other routes that may enable you to get immigration status, which would eventually give you the right to work without it being tied to your work specifically.
Thank you. What are some of my options if an employer breaches contract?
I can kick off on this one. So I think there are probably two aspects to my answer here. There's the options you have regarding unfair dismissal law, and there's also more generally options for breaches of contracts, claims and other kinds of claims. So in employment law, you can have breaches of contract for all sorts of reasons. You can have someone that's failing to give you your annual leave entitlement. They're not giving you national minimum wage or the wage you're entitled to under the contract. Those sorts of claims can be enforced. If you have that, if you can prove that's happened to you, then you can go to a tribunal and bring a claim in respect of that. What kind of claim would depend on the circumstances. You might have a claim under the working time regulations for holiday pay, or you might have a claim under the national minimum wage regulations. There are different kinds of claims, but you will be entitled to enforce that contract. One quick aside on that, while we're talking about holiday pay, is that claims have recently got much easier in the worker status context, because of a case called Smith and Pimlico Plumbers No. 2, which took place in November last year, where essentially what happened is the law was changed so to allow you to have rolled over annual leave in cases where you've taken, rolled over holiday pay in cases where you've taken annual leave each year, but you haven't been paid for it. So going back years and years, if you were taking time off as a freelancer, but you weren't given holiday pay, because you were perhaps misclassified as someone who's self-employed, when in reality you were a worker. In that situation, you will have a claim for years and years of annual leave to be paid to you. So that's something that's really valuable to workers if that's happened to you, and you actually discover you are a worker and you haven't been given holiday pay. You may well have claims running back a number of years. So that's you can take your employer to the tribunal. There's another aspect to that's worth discussing here, which is unfair dismissal protection, which is that if you're an employee, not just a worker, but an employee, and you've worked there in that workplace for 2 years or longer, then if your employer breaches your contract in what's called a fundamental breach, a really serious breach, for example, if they fail to pay you for a number of months, or they breached what's referred to as the term of trust and confidence, the trust and confidence you have in your in your working relationship, if they breach that, they've done something really nasty, really horrible to you, then you may be able to resign and claim constructive dismissal, which is a term that's thrown around often, and it's a bit of a difficult area of law. So I wouldn't recommend anyone to do that without having proper advice on that. But it is an option to think about if the employer has breached your contract so fundamentally that you want to walk away. And a final point I'd make on that is that you don't need always to take such action as drastic as resigning, particularly if you're not sure you want to resign, or if you're concerned about the financial implications that might have. You can work under protest, which is another term that you might have heard of before. And you can work under protest and say, I'm unhappy with the breach of contract the employer's just subjecting me to, but I'm not resigning just yet. I'm retaining the right to resign and claim constructive dismissal later, but I'm not doing that just yet. Again, these are tricky areas, so I'd recommend getting some advice before doing these things, but they are some options that are available to workers.
Are organizations who ask me to work with them as a freelancer having the right to check my passport or register me in their payroll, even if I'm not an employee? And what are some of my options in negotiating this?
Yes, I can start and taking the first bit, at least, of this question, and that is whether an organization can ask me to prove my right to work if I'm a freelancer. And unfortunately, the answer is that actually workplaces have to check the right to work. So even if you're working for them in a freelance capacity, if their procedures, or if they act with due diligence, then they actually ought to be asking you this question. So it's going to be very hard to challenge this or negotiate it, unfortunately.
Nothing to add on that question for me.
So what are some of the risks in organizing for freelance culture workers and migrants in particular, and is there a way to mitigate them?
I can start off on that one. Well, I suppose I'll start with the kind of risks to all workers seeking to organize, and then thinking a little bit about those particular risks that migrant workers and cultural workers face. So there are certain risks to all workers looking to organise. We at our union deal with claims very often where people have been subjected to a detriment for taking part in industrial action, for example, going on strike. And sadly, the law does have significant limitations in this area. For example, there was a case recently called Mercer, in which the Court of Appeal said that individuals that are subjected to a detriment on the grounds of industrial action don't have protection in law. It's only where there's dismissal on the grounds of industrial action that there's protection. That's hopefully being appealed to the Supreme Court and maybe to Strasbourg, but that's the law as it stands. Individuals get automatic unfair dismissal protection within 12 weeks of taking strike action. So there are some protections, but if there are detriments, if there are dismissals that you're subjected to before you take that industrial action or after those 12 weeks, the law is much less clear. So there are risks to all workers who are taking or organising and taking strategies against their employers, because they may well be consequences. The good news on that front is that the best weapon workers have against that is working alongside each other, working collectively, where employers will struggle to pick off individuals and detriment them, when the reality is that there are so many people involved, or a sufficient number of people involved, that they just simply don't have the muscle for that. So that's the main point I'd make about mitigation, is that collective action is much more effective even than legal action, which often deals with individuals and takes a long time for those rights to be enforced. I guess with migrant workers and cultural workers, though, these problems are exacerbated. People might be concerned about drawing attention to themselves with their work status. I don't know if that's something maybe Eva might want to discuss. So maybe I'll hand over to Eva on that.
Thank you. Yeah, so I think firstly, maybe to say that I would encourage everyone to organize, because I think really the benefits of organizing, we kind of spoke earlier about the importance of knowing your rights, and organizing gives you an opportunity to share knowledge with others, and to really build up your knowledge around this, and build up, tactics and strategies how to stand up against, being questioned or negotiating with your workplace. Now, unfortunately, as Finnian has already mentioned, there are of course risks involved generally, and unfortunately, particularly for migrant workers. So, for example, if you envisage someone who has a skilled worker visa, they are of course tied to their employer giving them sponsorship. And perhaps there's some concerns, and understandable concerns, that employers may choose to, stop sponsoring you or renewing your visa and things like that. So unfortunately, there is a precariousness to a migrant's position in these circumstances, which is enhanced. But in any event, as I said earlier, I would still encourage everyone just to speak to one another, and also, then negotiate or find out the risks that may be involved in organizing more formally.
So how can migrant culture workers challenge arts organizations to sponsor visas and to offer support?
Yes, so unfortunately, you don't have any legal provision to point to to force an organization to get a sponsor license. Obviously, it's, they can choose to get one, but they don't have to. But I think it's really useful to encourage them to do it, and to really explain to them the benefits of doing it. So, for example, I was speaking to someone about this very recently, but I think it's, if you work for an organization that is very openly anti-racist and wants to be anti-racist, I think getting a sponsor license, for example, is a very good way of actually showing material support to that commitment. And so maybe you can use arguments and think of ways in which you, just may be able to encourage your workplace to get a sponsor license, and really drawing out the benefits that it could have for the organization. And I'm really hoping that there are quite a lot of guidance documents from the Home Office online. Unfortunately, they're quite lengthy, but some of them I think they've beefed up a bit and tried to make it a little bit more user-friendly. And maybe you can use them as well to show your workplace that it may actually not be as arduous as it sounds to get a sponsor license and to get you onto that system. Yeah, so really encouragement would be my recommendation.
Okay, we've reached our final question. So just to say now, thanks very much to you both for your time. I thought we might end with kind of 3 main takeaways that you'd like to share with freelance culture workers who want to take agency in a hostile sector.
Who's going to start?
Do you want to go ahead, Eva?
Okay, I'm going to start with the first one. I think we've actually spoken about them before, so this is just maybe a summary of everything. So I think my main takeaway is really know your rights. Go on the internet, try and find out about what your immigration status is and what your rights are within that. And also speak to others, organize with others to understand your rights, and also to organize more widely and think about strategies in which you can challenge hostile policies or actions against you. Handing over to you, Finnian.
Thanks, Eva. So the second one that I think, again, has been spoken about and only applies to some cultural workers, but is a really important one, which is these worker status claims. And it's an aspect of know your rights, knowing your rights, as Eva's just talked about, but it's one really particularly important, because a lot of your rights follow on. A lot of your protections follow on from whether you're classified as a worker. So this is something that is going to become a bigger and bigger thing within this sector, is individuals that are told by their clients that they're self-employed. And as a consequence, they don't get sick pay, they don't get holiday pay, they don't get minimum wage. And the reality is they may well be workers if they're subject to a degree of control by that employer. If there's risks of work not being provided falling on the employer, i.e. that if you turn up for work one day and there's no work to be done, then you still get paid, or you'd still expect to get paid, then that might be an indication that you are a worker. The law is expanding on this. There was a recent decision in the Employment Appeal Tribunal just the other day where the tribunal said that the law is expanding, and even where little tricks that employers put into these contracts, such as a right to have a substitute, a right to you to get someone else to do your shift or do some work on your behalf. Those little tricks don't necessarily stand in the way of you being a worker status and getting all these protections. So I'd encourage anyone who's not sure about their worker status to get some advice and to see if they may be entitled to these really important protections like holiday pay and minimum wage. I don't know if you want to take on the third one, Eva.
I think I partly mentioned it. I think our third one was really organised. So yeah, do collaborate with others and organise. It's hugely important. There are risks involved in it, so be aware of them. But organising is a great tool to be able to fight against.
Thank you so much to you both. It's a good note to end on.